Workplace sexual harassment is three things: traumatizing, illegal, and very common. Studies show that around 80% of women and 40% of men will be sexually harassed at work at some point in their careers. And the sad reality is that only 1 out of every 4 victims of sexual harassment discloses it to HR, their managers, or anyone else. But today, more Maryland workers than ever are standing up against sexual harassment. And we're proud to play a part in making Maryland workplaces safe and welcoming for everyone. My name is Joe Gibson, and I'm a Maryland sexual harassment lawyer. Let's talk about it. You probably know that sexual harassment is illegal, but you might not know exactly what qualifies as sexual harassment or which laws prohibit it. Let's start with what qualifies as sexual harassment in Maryland. At its most basic level, sexual harassment is any unwelcome conduct of a sexual nature. Whether it's a friendly arm around the waist, or an accidental brushing up against you, or sexually charged jokes or innuendo, when it comes to sexual harassment, most people feel like they know it when they see it. But there may be a bit of a difference between what you see as sexual harassment and what legally counts as sexual harassment. There are 2 main types of sexual harassment: quid pro quo sexual harassment and hostile work environment sexual harassment. Quid pro quo literally means this for that, and happens when a supervisor demands sexual favors in exchange for something good, like being hired or promoted, or to avoid something bad, like a demotion or being fired. While we do see quite a few quid pro quo sexual harassment cases, they're far less common than hostile work environment sexual harassment cases. Hostile work environment sexual harassment is sexual conduct at work directed to you or anyone else that interferes with your ability to work by creating an offensive working environment. Now, this is usually where someone tells me that people need to lighten up, or that they're afraid that they'll be dragged off to court for a single inappropriate joke. But legally speaking, hostile work environment sexual harassment rarely applies to one-off events. Instead, it usually applies to repeated conduct. For example, asking a coworker on a date probably isn't sexual harassment. But if that coworker says no, and you keep asking, that is sexual harassment because it's repeated conduct. Similarly, a single off-color joke or comment usually isn't going to qualify as creating a hostile work environment. But a pattern of making sexually charged jokes or comments might qualify. When it comes to a hostile work environment, repetition is key. Now, there's an exception to that rule. If a single instance of sexual harassment is extremely severe, and for example, involves unwanted physical contact or even sexual assault, that will immediately qualify as legally actionable sexual harassment. Unfortunately, determining what qualifies as sexual harassment is a case-by-case analysis, which is why it's so important that you talk to a lawyer about your specific situation. Now that we've talked about what sexual harassment is, now let's talk about some of the laws that make it illegal. The federal law prohibiting sexual harassment is Title VII of the Civil Rights Act of 1964. Now, the important thing to know about Title VII is that it only applies to Maryland employers with at least 15 employees. There's also a Maryland state law called Title 20, which prohibits sexual harassment and, like Title VII, it only applies to Maryland employers that have at least 15 employees. There are also a number of Maryland counties that have their own laws against sexual harassment, and some of these county laws apply to all employers, regardless of how big they are. Here at the Center, when we evaluate sexual harassment cases, we look at each federal, state, and local law to determine which of them is most applicable to your situation. The last thing you should know about sexual harassment in Maryland is that you have very strict deadlines or statutes of limitation to file a complaint. Depending on whether you're filing under Title VII or Maryland's Title 20, you can have as little as 300 days or as long as 2 years to file a complaint. But these filing deadlines aren't really the biggest issue. In our experience here at the Center, evidence and witness memories degrade very quickly. And if we're able to preserve evidence and talk to witnesses right away, you're generally going to have a much stronger sexual harassment case. And there's really no reason to delay talking to a lawyer. Here at the Employment Law Center of Maryland, we can generally get you a same-day consultation with a lawyer, and that consultation will be both free and confidential. If you need to talk to a Maryland sexual harassment lawyer, you can reach out to us on our website at www.elcmd.org or by calling us at 240-384-5705. At the Employment Law Center of Maryland, we sue bad bosses.